I'm Marty Abrams, and I lead the Information Accountability Foundation. And this panel is beginning to ask the question, if you can demonstrate that you're a truly accountable organization, should you as an organization get benefits from that? And that political judgment, by the way, was already made at one point in time in Spain, where they changed the Spanish law in 2011 to give benefits to organizations that could demonstrate they were accountable. Their penalties for having an infraction were reduced based on having a program and not having a systematic problem. So there has been some evidence of that. But before we get into this whole question of the question of benefits, there has been an accountability movement in the area of data protection that started about 2009. At that point in time, there was a sense that if we went back and looked at the OECD guideline on accountability and begin to give some flesh to that, we would begin to understand better means for assuring that data is transferred over space and time in a way where obligations would really stay with that data. And a meeting was called, that was held in Dublin. It was called the Galway meeting, even though it was in Dublin, so we renamed a room at the Dublin Castle called the Galway room. And out of two sessions that were held in Dublin, we came up with the essential elements of accountability. And since then, we've been building out instruments based on the essential elements of accountability, probably the last being a document that came out from the CNIL last week. Terry McQuay, who is a good friend, has been asking me questions constantly since we started this accountability movement in 2009. And Terry has captured the essence of accountability in privacy management processes or activities, and has created a process for demonstrating that an organization is indeed accountable, because accountability requires you to be both responsible and answerable. And he is about to issue a paper, and we have copies of the draft, I believe, for the audience. Is that correct?
There's to be handed, yes.
They will be handed out. That argues if an organization can truly demonstrate that it is accountable, that they should get some benefits for that, and Terry will explain some of those benefits. The other point he makes is that this does that this is enforceable by regulatory agencies based on the concepts of cooperation. And with that, I will introduce our panel. First, our moderator is Colin Bennett, and most of you know Colin. He's a distinguished academic from Canada, which makes him special, because everybody from Canada is special. We have Chris Docksey, who is at the EDPS, and Chris has been in front of this audience many times, and as many of you know, the EDPS has pushed hard for the European agencies to truly be accountable and be able to demonstrate that accountability. Michael Scuvée is with Johnson Controls, and he's built out the accountable program at Johnson Controls, making some of the use of the tools that Terry has developed over time. And Scott Taylor was actually in that meeting in the first pre-meeting in Dublin, where we decided to actually do an accountability project. And he too has built out an accountable program at Hewlett Packard. And last but not least is Terry McQuay, who actually wrote the paper that we're going to discuss today. And with that, I turn it over to Colin, who is the moderator.
Okay, good morning, everybody. I don't have anything to say at this point, but we're going to go in the order of Terry, and then Christopher Docksey, and then Michael, and then finally Scott. I'm then going to ask a few, hopefully, provocative and penetrating questions about accountability. They will then answer those questions, presumably, and then we'll open it up for the audience. So we're going to kind of keep the presentations from the panel quite brief, so that we've got plenty of time for Q&A afterwards. So with that, Terry.
Good morning. I'm Terry McQuay. The You were supposed to receive one of these when you came in, and hopefully you did. If not, we can get you a copy of that. So the underpinnings of today's discussion does come from a paper that I wrote, and it's in a draft format. So this is a feedback session. But it essentially is the premise here is accountable organizations deserve benefits or can achieve benefits, and benefits that are provided by the regulator. And I'm going to walk through a few premises first about how it's structured, and then I will be turning it over to the next speakers. So the first premise here is that accountability goes beyond compliance, okay? Accountability results in compliance, so think of it as an effective or robust privacy management program implemented across the organization is going to result in compliance. But it also goes beyond compliance. And the example that we use in the paper, but there's many examples that right now, for example, around the world, there's only 13 countries that have privacy law that requires employee training. There are 16 countries that have the necessity to have breach protocols. So that means you can be compliant in many parts of the world without necessarily having a training program or a breach protocol in place. But there's no way you could make the claim that you're accountable without training your employees, without having a breach protocol, without having a number of other accountability mechanisms. So the first premise is that accountability goes beyond compliance, and the underpinning of that is that you need to be compliant to be accountable. So that's the first point. The second point here is that the paper is written maybe not necessarily for everybody, but it's written for these individuals. And it's written for the organizations that have a privacy officer, privacy office, that want to invest in privacy management, further invest in privacy management to build robust privacy programs and have compliance. But it's also for regulators that want organizations to invest further in privacy management, to go beyond compliance and have robust privacy programs. And this is taking place. So for example, in Canada and Hong Kong, they've already issued papers to such effect. And we know that Bulgaria and Colombia are writing papers just like that to getting started, to getting to accountability, a type of approach, and there's likely others that are taking this approach. That's premise number two. Now the approach in a way is quite simple. An organization can voluntarily participate in a program set up by the regulator that they would have to maintain an effective privacy management program, but they would have to stand ready to demonstrate it to the regulator on demand. The regulator, on the other hand, would create this policy, and it says that, okay, if you stand ready to demonstrate to us on demand and allow us to come in or voluntarily allow us to come in at any time to do a visit, well, we will provide benefits for doing so. There's incentives for doing so. I'll go into it a little bit more detail, but that's the core of it. But there's no real reason to get into it any further unless it's possible, right? Because you have to be able to demonstrate accountability to a level that a regulator would find effective. So I'm going to walk you through a short exercise or illustration. You all, for the next 2 minutes, are a privacy officer. You're a privacy officer in a responsible organization, and you have resources, and you've built out a robust privacy management program. Therefore, you are accountable because you have a privacy program that you've implemented, but you've also influenced all the processing of personal data throughout the organization, effectively taking your data privacy policy and implementing it throughout the organizations in other data processes. And you've observed the processes that are in place in areas that you have limited influence but are protecting personal data. And as a privacy officer, then you could actually collect the documentation that is produced organically from these privacy management activities. Whether you put them in, whether you influenced them, whether you observed them, they all produce documentation, and that documentation can be collected by the privacy office. But as a privacy office, you also understand the laws to which you need to comply with. So you understand the data protection law in the jurisdictions to which you reside. And as a privacy officer, you can read through that law and you can identify the provisions in that law that would require evidence. Evidence if you were to demonstrate compliance. Why do I say that? Well, privacy laws have tons of provisions in there that you do not necessarily need to evidence to demonstrate accountability. The example here they're looking at is the Dutch data protection law. It has 98 provisions or rules in it, and 34 of them would require documentation to show compliance. If you take the UK law, they have about 209 provisions, but it's essentially around between 30 and 40 that need evidence. So what do? Well, you take that documentation that was produced organically through the privacy management activities throughout the organizations, you collect that and you align them to the particular rules of law, and now you can communicate accountability to a regulator based on their law. So you're demonstrating accountability where the law is the underlying framework for demonstrating accountability. So that's the premise number 3, is that you can demonstrate accountability through operational documentation using the underpinnings of the law itself as the framework. So the final premise here, that before we kick it off for everyone else, that what we're talking about here is good for regulators. So now you're a regulator for a moment. You want organizations to be able to demonstrate compliance because you, at the end of the day, have a law or laws that you have oversight for. 2, you do want robust privacy management throughout the organization because you understand that robust privacy management, the outcome of that is compliance. And 3, it would be nice if there was a way to differentiate between the organizations that are accountable and the ones that, let's say, have not yet invested in privacy management. So what do? So you can create incentives, and what we're calling for is enforcement leniency as one. And that's not really a stretch, because today regulators, when they're doing investigations, in most part, they come into an organization that has an incident of non-compliance of some kind, and they have robust privacy management, they have leniency. But we're calling for it to put it in policy. And then, if you're in one of the 84 countries around the world that have restrictions on cross-border data transfers, then we would say there's less restrictions on cross-border data transfers, and here's why. So the organization, the privacy officer, can demonstrate accountability to the law in the jurisdictions they're within. But what if the privacy officer could demonstrate accountability to the jurisdiction to which the data is being transferred, but on the law to which the regulator has jurisdiction? If the organization could do that, is there any reason for the restrictions of cross-border data transfer? They're compliant. And the third part is if you're in one of the countries, the 82 countries that have notification requirements, if you have an accountable program in place, we would call it for exemptions on notification. But this works for the regulator because of the, Richard Thomas has the expression, be selective to be effective. And I'm saying, well, selective is effective because the policy would allow for the regulator to do spot checks to the organizations that voluntarily participate, but not to all of them. And they would, therefore, doing a sampling would be effective because everyone would know that they would have to stand ready to demonstrate. That keeps the privacy officer with the resources that they need to be able to stand ready to demonstrate these spot checks. But the organization is ready to demonstrate, so there's efficiencies there. So it is an efficient model. And then finally, to wrap up this premise, is providing organization the incentives is going to provide the privacy office with the ability, the resources and the ability to stand ready to demonstrate. It allows regulators to be effective. But to wrap up, the results of this is that there's no third-party verification required because the regulator can do that on demand. There's no need for verifications from a third party. It's supposed to say not safe harbor. It's not a safe harbor system because it's a leniency and benefit system, but we're not saying you're exempt from the law. And it works with existing laws, so it can be put in today, and it allows the regulators to do more existing results. I mean, they can do more with the existing resources, but ultimately the outcome is increased privacy protection for data subject, which ties us back to the premise number 2. Isn't that what the responsible organizations want, and they have the privacy office to do so? Isn't that what the regulators want? So that sets the stage for our conversation about accountable organizations receiving benefits from regulators. And that wraps up my...
Thank you, Terry. So now the regulator's perspective, Christopher Docksey from the EDPS.
Yes, let me find it.
Thanks, Terry. Welcome to everybody who's made it this ungodly hour as well. You're supposed to maintain eye contact with your people you're talking to, but when... I'd just like to look at accountability from three perspectives. Oh, we're up. And say why I think the time has come for accountability. And these three perspectives are us, the EDPS specifically, very briefly, regulators in general, and how we see controllers, but we're surrounded by controllers, so we'll have their views. And I'd just like to put this debate into the context of the data protection reform, particularly accountability and sanctions. The EDPS is the EU Data Protection Authority, and we have three roles. We advise on legislation, we supervise the EU institutions and bodies, so we're like the German Federal Data Protection Authority, we're a public service regulator, and we're an EU institution and a controller. So we process personal data ourselves. And so when we talk about accountability in any of these roles, it's on these three experiences that we have. And we really believe that you don't actually need new legislation to be accountable, and you can do it now. And so we published this paper in November 2012, and we told the bodies that we supervise that they should start being accountable. And by that, what we meant is that they had to be proactive, and they moved to a situation where they take responsibility for putting compliance into place. Now, if I move to the more general perspective of the regulator, the interest in accountability is that we just don't see most processing. It's like the tip of the iceberg that Anne Cavoukian talks about. We see that, we get complaints, so that shows us something, but how do we ensure respect for privacy below the waterline, that vast number of people processing personal data? And we see accountability as the answer because it gets controllers to do it themselves. And it works on a basic premise, which is that most people, most controllers, actually prefer to comply and respect the rules if they can. They would like to get it right if they know what to do. And we'll come back to this, and it's there in your paper, Terry, but for us, a key condition for accountability is having an in-house data protection expert. We call it a data protection officer, a privacy officer, whatever. But if you've got somebody like that in-house, then you have a sporting chance of getting going with accountability. And then you have the result, which is proactive data protection. And in this time of change, it's really useful, an accountability approach, because it deals with the things that are most difficult for regulators to get to. Cloud computing. We all know the legal problems with cloud computing. It's even more invisible than ordinary processing, and there's a huge benefit in getting it right. And the significance of the Google Spain case that created such interest last year is you may be in the cloud, but the EU rules will apply to you if you do business here. So it is in your interest to get this right. And it's the same for international transfers, and you've talked about that a bit, Terry. Again, a loss is invisible. There's a huge benefit in getting it right. And one of the other cases that created huge interest last year, the Digital Rights Ireland ruling on data retention, had a very enigmatic paragraph 68. And a lot of people really don't know what it means because it's got a bit missing. But what I think it means is that you can't send data outside the EU and outside the control of your local data protection authority without adequate safeguards. Accountability will do that. It doesn't mean, I don't think, that you can't send data at all. Now, Terry talks about benefits, and I think it's absolutely right that if you do accountability and you get it right as a controller, you will definitely get bunny points with both regulators and the courts. Regulators definitely take an accountable organization's achievements into account, and so do the courts. And this is an advantage you don't mention in your paper, Terry, but it's one that's very, very real for us as EU regulators. And in fact, the EDPS, when we intervene in court cases before the European courts, the first question we hear the court ask actually is, did you notify the processing in question? Which, what they mean by that is, did you think about what you were doing? Have you done what you could do to avoid the infringement? And when we get into the benefits discussion, we'll have to remember that the courts and data protection authorities are the two sides of ensuring that individuals have their right to data protection respected. Then if we move to the controller's perspective, I'll do that quite quickly as we have controllers here, but what we see is an interest for controllers in terms of in combating the lack of trust that's come out post-Snowden. We heard a lot about this in the data retention panel, the crypto wars panel, and we know the industry itself is even asked data protection authorities for support in terms of rolling back this lack of trust. There's a huge advantage, just risk management and privacy risk management in enhancing the trust of customers and the direct relationship with customers. There's a big advantage in respecting the existing rules and being ready for the future. And especially two aspects I'm just going to talk about. Firstly, avoiding legal liability. I mean, the standard approach is notify and hope nothing happens. And this is not enough. And all the controllers who are suffering from data breaches with this approach are learning that the hard way. Now, what the reform will do in this context is two huge differences. And the first is it will change the economic balance of non-compliance by introducing humongous administrative fines. And whatever the final decision is in the legislator, whether it's going to be, and the key fine is a percentage of annual worldwide turnover. You're not talking about parking ticket fines as exists at the moment, whether it's 2% in the Commission proposal or 5% as the Parliament has suggested. This will change the economic balance for compliance. And then if I look at the second huge change, that will be the legal concept of accountability being introduced under the reform. I started with accountability way after you guys. I'm a real beginner compared to my august colleagues on this panel. But I started basically in 2010 with the Article 29 Working Party opinion, and that discussed how can the legal framework encourage controllers to take measures that deliver real data protection in practice. And we came to the conclusion you need an accountability-based mechanism. And that you can see in the draft regulation on data protection in Articles 5 and 22. And it is basically an ensure, demonstrate, verify model. You can see the wording of it, adopt policies, implement measures, and be able to demonstrate. And what are the appropriate measures that are envisaged? You do have a list in the regulation, and the problem with these extra measures is there's a threshold, and that's a whole discussion in itself. But as you can see, they include really quite basic measures such as a documentation and impact assessment. And I would say the single most important one is the designation of a data protection officer. And in our experience in the EDPS, it is the data protection officer, the privacy officer, that makes the difference. We've done surveys of the bodies that we supervise, and we find that the level of effective compliance is really in correlation with the experience and the feeling of independence of the data protection officer. I'd like to stop now just with a question which is there at the bottom of the slide. And it's a question that interests me, and it is, if we have this legislation adopted, and I hope we will, and I hope it'll be this year, things are really finally moving, which is looking good, once we've got this good stuff in place and it's a legal obligation, if you're a controller and you do what the law says, are you compliant or are you accountable? Thank you, Marty.
Thank you, Christopher. And now Michael Scuvée.
Hi, everyone. So just as an introduction, just a few words about the company I work for. So I work for Johnson Controls. So that's a multi-industrial company. We operate in 150 countries over the world, and we have about 170,000 employees. So we have activities, manufacturing activities in different sectors, which are the building industry sector, where we produce HVAC system, control systems for buildings to make them more energy efficient. We produce car interiors, car seatings, and also a large business into the power that we call power solutions into car batteries mainly, including recycling of car batteries. So just to talk a little bit about the kind of sector we're in, because the point I want to make is if you think about a manufacturing company like Johnson Controls, we are not like, you know, the companies that you read in the newspaper. We're not the Googles, we're not the Facebook, we're not Amazon or all of these social media players. However, privacy compliance is very important to us, as well as accountability. And now I will talk about accountability a little bit more right now. I just want to give a few examples of why accountability goes beyond compliance. So we've heard about this in Terry's presentation already, but some examples are like, for instance, privacy impact assessments. Today we don't really have a legal obligation to run privacy impact assessments. However, if you really are serious about understanding your practices and documenting properly your processes, how do you want to not do privacy impact assessments? So for instance, if we launch, for example, a new payroll system globally, or if we launch a new travel system globally, the only way for us to really map our data flows, to understand our relationship with the different vendors, verify we have appropriate privacy provisions in place, that they apply appropriate security to our data, the only way we can do that is via privacy impact assessments. So we've run, over the last 2 years, I think more than 100 privacy impact assessments, even though it's not mandated by law. Other few examples, audits, same thing. We also run a certain number of audits around privacy. We target those audits to where we believe there are the most risk, where we have big shared service centers, for instance, which process massive amount of data. Just make sure that the people are accountable there, that people understand our policies and apply our policies. Another example as well is the DPOs. So we do have a certain number of jurisdictions where DPOs are mandated by law. Thinking about Germany, for example, you have to cover each of your legal entities with DPOs, and it's a formal appointment. Up till recently, Slovak Republic was also one of those countries where we had this kind of obligation. But anyhow, if we really only do that in those jurisdictions where we have such kind of legal obligation, how do you make sure that in every single country where you operate, they also apply the same controls around privacy? So what we have decided to do is to create a community of local data privacy coordinators. Even in those countries where we do not have an obligation to appoint a DPO, we have a coordinator, someone we can work with, a contact point, someone that can elevate or escalate any question if that's, or any problem if that's necessary. Also trainings. Again, trainings, we do not really have a formal obligation for trainings, but really if you have those policies, if a policy is just a paper that stays in a cupboard, it doesn't give any advantage to the company. So we have trained last year about 35,000 people, which is quite a massive investment for us as well. So developing e-learning trainings translated in 30 different languages. So it was quite an investment, but I think one that really helps evangelizing the privacy inside the company. Another thing I want to say here is that if you hear about all these things about privacy impact assessment, setting up a community for privacy, auditing, and so forth, what we're talking about essentially are activities, right? So concrete activities. And very often, I think that this is where there's a big difference between accountability and compliance, is the law typically gives you a certain number of principles that you have to respect. You have to respect transparency, you have to respect the principle of proportionality, but really, how does that translate internally? How do you communicate to your management and to your colleagues worldwide what they really have to do to respect proportionality? And that comes down to a certain number of activities, and this is why it is so important in order to drive a momentum and to drive the execution of your privacy program into the company, to work with an accountability framework which describes those activities. So now I just want to finish with just a word about then how do you then demonstrate accountability. We have recently gone through the whole binding corporate rules process, which have been approved in beginning of January now, and that was one of the key discussions that we had with the regulator. They were asking questions about not only documenting your binding corporate rules, but how you demonstrate the effectiveness of those rules. And what we have done is we have also taken all the requirements related to the BCR into the Nymity framework and really try to identify which pieces of evidence do we have to demonstrate our compliance with the specific provisions from Working Party 153 from the Article 29 to just be able to produce evidences to the regulator that we are accountable and that we effectively comply with these standards. So again, as a conclusion, I think that there is no effective privacy program without real accountability and without real measurement of the activities and how you deploy those inside the company. And then compliance is normally the natural outcome of that. Yeah? Okay. Right. Thank you.
Thank you. Everybody's admirably on time. This is wonderful. Finally, Scott Taylor from Hewlett Packard.
Thank you. So I'd like to continue to talk a little bit about accountability and what it has meant to us. It's interesting. Accountability has become, without a doubt, the foundation of our privacy program worldwide, but I want to talk honestly about why that happened. HP, since we initiated privacy, we have followed a European standard. And we follow that standard worldwide. It's made it easier for us to comply with Europe, but also to implement a European standard everywhere where we operate. We're also a very large corporation, close to 400,000 employees worldwide. And it's quite difficult, actually, to manage a privacy program jurisdiction by jurisdiction. At the time, the European directive was the best approach for us to create a unified standard for the company everywhere, even in countries where laws don't exist. And it has been very effective. But accountability and my work with Marty actually started back in 2006. And accountability became important to our company specifically because of an incident that we had. Some may remember a very visible issue that HP had with our board of directors. And there were leaks coming out of our board of directors. And we had a lot of pressure from the Securities and Exchange Commission in the United States to stop those leaks. The way that we discovered who on the board was leaking that information turned out to be, quite frankly, an unethical approach to surveilling the board members and their cell phone records to figure out who was leaking. At the time, it was just an investigation in the context. We were trying to do things the right way, and it got out of control. That was prior to me coming into this job. I came into this job actually as a result of that issue. So we had a reason. We had a consent order from the state of California of inappropriately surveilling our board members in an investigation to understand wrongdoing. What we realized through that process is that HP complied with the letter of the law. We didn't do anything wrong from a legal or compliance standpoint, but it was certainly not ethical. And so this concept of ethics and doing the right thing and being responsible was very important to HP in trying to ensure that something like that would never happen again. So we got introduced to accountability in a very different way in our privacy program. Marty mentioned the 2009 effort when we began the accountability project in Dublin, Ireland, and that has been a very good process in terms of helping us to prepare for what we didn't at that time realize was coming, which is a very different environment today in terms of the things that Christopher talked about. The world has changed. That original project was focusing on moving organizations from pure legal compliance, the letter of the law, to concepts of responsibility and demonstrating that responsibility to authorities or to other agents that represent authorities. And we began our BCR process many years ago, and certainly as we started looking at accountability, the BCR process certainly is an early example of an accountability-based program. So WP 153 and 154, I think, really set this kind of high-level principle-based approach that helps us to understand accountability and how you might implement that and ultimately demonstrate it. And I think we see after BCR's cross-border privacy rules in APEC, a much lighter version because of the nature of those jurisdictions, but also another important accountability program. And I think that what it has resulted in, BCRs and this concept of accountability that Marty began working with industry, regulators, and civil society on, is it has started to elevate, as Christopher said, the internal approaches of privacy programs, and it has changed our roles from pure legal compliance to really trying to help an organization, each of our organizations, do a much better job. In terms of implementing accountability for us at Hewlett Packard, similar to Johnson Controls, we had put together a very early framework, and that is based on 3 key pillars. One is that you have very solid policies that are supported from the highest level of management that align to external standards. In our case, our primary alignment is to the European directive, which makes it much easier to align that to other jurisdictions around the world. The second is, beyond those policies, as we heard earlier, they're nothing but words on a page unless you have the second pillar, which is an ability to implement them and put them into effect inside of the organization. That involves everything from privacy impact assessments to good training to consultation from your privacy office to the business that's actually putting them into effect. But both of those things are useless unless you have a way to assess them. And that can come through normal assessments, that can come through auditing. We have both internally, but you need to make sure at the end of the day that they were implemented in a consistent way that you expected they would be implemented. And through that entire iterative process, you can continually improve the program. But there's a piece that's really important, which is governance. And the governance piece is really about ensuring that all of the parties and stakeholders inside of the company that have an impact on the collection, the use, and the retention of data are involved in a strategic process. Not only to look at what we decide to do to ensure it is responsible, but also to assess the risks and mitigate those risks so that you don't have incidents happening. And then at the bottom of those 4 things is the ability to demonstrate. And what we have found very helpful is that if you have your act together in those 4 areas, it's pretty easy to demonstrate that you're doing a decent job, that you're being responsible and that you're being accountable. That demonstration can take place internally with stakeholders. It can take place with intermediaries, such as trust agents. It can also take place directly with the regulators. I believe a regulator at any time should be able to come to a company and say, explain to me how you actually manage your program. and allow us to then go into context and explain how we handle a particular transfer, a particular part of the business, or a particular issue. So that, to us, is what accountability is about. Now, this original project that Marty began, he has evolved this over time. Accountability, he's termed a phrase accountability 1.0 and 2.0. And I'll try to put that a little bit in context because I know Marty's going to talk about it. The original accountability project, as I mentioned, was really trying to move organizations from pure legal compliance, where lawyers are interpreting individual country laws and giving advice to an organization of how to comply with that law. We all know as practitioners, it's not that simple anymore. Data is no longer being put on magnetic tapes into boats and shipped from one place to another. Data is moving around the world continually. I would also argue that 2.0, accountability 2.0, is really actually extending this concept of moving from legal compliance to responsible practices that you demonstrate, to a concept of needing to make more complex judgments that ultimately involve ethics. And if you just think about what Christopher was alluding to in his presentation, the globalization of data has put real strains on some of our traditional laws and the guidance that they provide. Compliance, legal compliance, is simply not enough anymore. Distributed environments, Christopher mentioned cloud, but just think about this mobile device that we are all carrying. The concept of a data controller, a single data controller, has fundamentally changed. Now, there are cases, if you buy a printer from HP or a PC from HP, you, for the most part, have a single data controller. But I would argue that the day that we started producing Chromebooks, I'm not sure if you have a single data controller. And certainly on these devices, who is the data controller that's collecting information? There are many data controllers. And our laws are struggling to handle how we would deal with transparency or notice when there's not just one company fully responsible for all of the things being collected from this device. And then the concept of advanced analytics, big data. I know for me internally, this has really changed in the last 2 to 3 years. The complexities that are coming with big data are really requiring us to rethink how we are guiding the organization. And at the end of the day, the answer of is this fair and is this responsible, in addition to is it compliant, these are getting more and more complex for those of us internally who are responsible to guide our organization. Terry mentioned that at the end of the day, really, his program, which is very helpful in helping companies to organize the information and the demonstration of their accountable practices, I think Terry said something like, you really ultimately want the regulator to feel good about what you can present in terms of your responsible practices. I would say that today with big data, the types of questions that we need to ask to come to a conclusion of whether something is accountable and responsible and ethical are very complex. I think it's going to be critical that our systems like Terry's to help us to document that and to help guide us through that process. But the interrogation questions of whether something is fair, whether something is responsible, and whether there's an appropriate balance between the organization and the rights of the data subject, this is becoming much harder for us to do. These ethical judgments are something that we're going to also have to demonstrate if something goes wrong, and it's just becoming more complex. So I think maybe I'll end there. I have comments related to benefits that I can certainly address during the question and answer. So thank you.
Okay, thank you very much. We now have plenty of time for questions and so on. And I'm going to start off with a couple of big questions. I've been asked to be provocative and objectionable, so that's what I'm going to be. I'm a data subject. I'm an individual. I don't care whether you're accountable. I care whether you're compliant with the law. I think your organization, for example, is capturing too much data. I don't think you're compliant. I want to complain. I'm unhappy. And not only am I unhappy with the organization, I now find that my regulator, who should be protecting me, has said in advance that they're going to be lenient, if I understand this scheme correctly. The regulator has said that you will get, what was your scheme for brownie points? Was it bunny points? Bunny points, yes, okay. I think it means, it's a technical term, it means the same thing. That we're not going to fine you so much, you're not going to face so much liability. I'm the person for whom this whole system of privacy law and accountability mechanisms should be protecting. And I'm not happy because I see that there's this arrangement that's been set up between accountable organizations and the regulator, and I feel left out of it. So who wants to respond to that one? Marty Abrams.
It's really hard for me not to talk, so let's just acknowledge that occasionally I want to respond. First of all, your question is absolutely right on, and one of the essential elements of accountability is individual participation. In an observational world, that makes individual participation much more difficult, Colin, as you know, because less of the data comes directly from you in a way that you're aware. More and more the data comes from the observation of your activities with others. So the fact is that one of the challenges we have outside of this session today is how do we really address the issues related to individual participation, including how do we make uses of data more visible to individuals so that there can be critical questions like the ones that you pose. Second, the question of leniency isn't the question of leniency, it's a question of efficiency. To be effective, you have to be selective, and part of being effective to be selective is the ability to say that there's organizations that have put forward evidence of their compliance. That gives me more time to look at those who don't. But as a former regulator, and I'm a former bank regulator, the one thing that you never want to do to a regulator is con a regulator, because there's nothing worse than the temper of a regulator that has been conned. So if an organization falsifies the evidence that they put forward to establish they're accountable, then the penalties should be double. And typically they will be, because you've conned the process. And that a very important part of this concept of accountability is the spot checks. So the fact is that we have two companies at the table who say they're accountable organizations and who stand ready to demonstrate that. Well, regulators actually have to make some set of them do that, because for that concept of the standing ready to demonstrate to happen, there has to be a call to demonstrate on occasion. And if I were a regulator and I find a significant portion of the organizations that say they're accountable don't and are actually flawed programs, then the book should be thrown at them. The third concept, and I think this is really important, is that the observational world combined with advanced analytics has put different emphasis on the essential elements of accountability. And part of the second essential element of accountability is the concept of understanding the risks you create for others and how you're going to mitigate those risks. Now, if you look at the push in Europe to use more and more of the legal basis of legitimate interests and the balancing tests related to that, what you're beginning to see is a need for different tools to both establish good judgment, but also then to be able to demonstrate that judgment. And I think it moves us from the concept of legal certainty, which has been a goal of privacy officers and regulators for years, to the concept of a legal probability. In other words, if I'm doing a high-quality job of understanding the risks, assessing them, balancing them, and they're not just about autonomy risks, they're risks about not using data when it's appropriate to use data, then you actually have an outcome that takes you well beyond compliance.
Scott?
Colin, I'd like to comment on the concept of leniency. For me, what leniency translates into is something a little bit different. So I'll use a concrete example of binding corporate rules, because I think that that's probably the best way to talk about an accountability-based program that makes sense to everybody. So outside of our company, I would argue at this point in time, the French regulator, the CNIL, probably knows our program and how it operates better than any other external party, other than maybe Marty. And this is actually a very beneficial thing. Marty is right that you don't falsify documents, you don't create artificial things. You need to be very honest with the regulator, and the benefit of BCR is that you have a lead regulator, in our case the CNIL, that you sit down in a lot of hours to explain to them. They ask a lot of questions so that they can truly understand whether you have a comprehensive and responsible program. This is better than any audit, external audit that a company can receive, to have a regulator scrutinize the program and provide you input and see you make changes based on their input. Leniency to me is that the regulator knows that you as a company are really trying to do your very best, not only to respect the law, to respect rights of individuals, but to balance the tensions, because it ultimately comes down to a balancing of tensions. And when a regulator understands that you really are trying to do your best and be responsible, if something goes wrong, leniency to me is not that we have a lower standard or that we get away with certain things because we're accountable. It's that we have a second chance, that we have an ability, instead of a fine coming, we get a phone call to say what went wrong. And then you sit down and you explain what went wrong, where it went wrong, and how you're going to fix it. And through that process of being able to have that dialogue, it may result in not having a fine if you can prove that it was truly an honest mistake and that there are ways to mitigate. But it could, in fact, result in a fine. It depends on the context. But for me, leniency is that you have a chance to explain yourself because you have a relationship and an understanding that you really are trying to do your best job. So there are other benefits that certainly can come as well that are not related to leniency. As Terry mentioned, data flows. With BCRs, an ability to move data around the world because we are seen as a credible organization within the organization certainly helps us in terms of administrative burden of not having to do model contracts. So there's all kinds of benefits that can come.
Terry, quickly. And then
Sure. My answer to the question, there is no change. If the individual complains and they do the investigation, what happens today, if they come in and find the organization's behaving responsibly, there's leniency already put in. But if it's non-systemic, like if it's a huge problem, then they're going to be outside of the policy because they don't have a responsible program in place, and then the regulator would enforce as they would today. So there's no change for that individual, but there is a change for data subjects overall, because the quantity of those type of incidences of complaints should drop if organizations are behaving responsibly.
Yeah. Yes.
I think again, I'm referring to the DPO because if something happens, in practice, we will call the DPO and ask what's going on. And there's a relationship of trust. And I'd just like to support what's been said, that the leniency and the trust has the result that you're going in with an open mind. And it can be relatively easy to be convinced, well, actually, we've done our best and there's nothing wrong here in reality. But if you then and I go back to now what Marty was saying, if you then get a complaint from an irascible individual like you, Colin, and says, this is all garbage, this is what's really happening, that's a sort of litmus test for the regulator, because that then makes us think again and say, oh, they're not
but-
doing what they're supposed to be doing.
Yeah,
And
but
try-
you see, my hypothetical was not about risk. It was not about non-systemic changes. It was about real disputes about the interpretation of the law. You know, what does compliance mean? And I think the issue here is that all of these lovely accountability mechanisms, and I'm very supportive of all of the work that's being done here, is based on a particular interpretation of the law, which may be very contested, right? Is that personal information? Is it not personal information? Are you collecting too much personal information? Are you not? Is that sensitive data? Is it not? All of the issues that the regulators have to deal with. And it seems to me on those big questions about what compliance actually means in a particular context for a particular industry, the data subject and the organizations that represent data subjects, the privacy advocates, are sort of out of the picture. That was my concern, and it still is.
If I may. What we're proposing here gives a framework for that to be discussed, because now you have both the documentation aligned to the law with the context. Now you can have meaningful conversation of what compliance really means.
Okay. So can I just, okay, Marty.
I think the nature of, we're talking about data protection here, and I think there's incredibly useful paper because of this whole question of what is in play and how do you interpret it. It's a paper written by Peter Hustings, who was the former EDPS, and it was released in October of last year, and it discusses the nature of data protection and the regulation. And I think that Peter asked the question, what is the difference between privacy and what is the difference between data protection? And it begins to bring into play the types of debates that you're suggesting, Colin, and I think they're incredibly important in an age where the data expands so quickly and so little of the data comes from us in a way that we understand it's coming from us. Sure. And so I think that debate needs to take place, but it needs to take place in the context of data protection is more than just the issue of autonomy. And I think that's a very important part of this discussion.
Okay, well, one second issue I just want to raise, and then we'll open it up, and it has to do with the A word, audit. And I guess this might be a question for Christopher. I mean, this model here is based on spot checks. I think that's what you mentioned, Terry, spot checks, site visits, and so on. I mean, what would be wrong with actually going further here and for the regulator to say that in order to get this leniency that you're asking for, we're actually going to insist on some real third-party audits? Now, one or two, I think both of your companies have done that from time to time, but there's plenty of experience of that. I mean, real third-party audits, technical audits that get below the waterline, as was saying. DPAs do not necessarily have the resources and the personnel to do regular audits on a regular basis. So what is therefore the role of third-party auditors in this process, accounting firms, standards organizations, in ensuring for the regulator that there is real compliance right throughout the organization?
If I may. So in the Working Party Paper 163, they're looking for a system in the accountability paper. Yeah. And one of the major objectives in there is scalability. And scalability for putting in accountability, measuring accountability, and those type of things. And if you introduce the concept of third-party verification across the board, you lose your whole scalability aspect, where the scalability is built into this system. The second point is, we're not saying no to audits and third-party verifications. What we're saying is where the scope is required, or where it's justified, where it makes sense to apply them, that third-party verification would fit into the overall demonstrative accountability. So if there's certain data processes someplace, high sensitivity, then they would have that third-party verification as part of demonstrating accountability.
I would just say that when the Article 29 Working Party was considering accountability, it did, I confirm it was very much the way that it was seen, is to use third-party verification. On the other hand, well, we have the right to go in and inspect any of the organizations we supervise without notice if we need to. And I think it's very important for the regulator to itself, you know, to put its hand into the wound. I think we're much more comfortable with doing verification ourselves than handing it out to a third party.
Oh, okay, one quick comment and then we'll open it up.
I could just say a word about third-party auditing as well. I think that there's also an element which is quite important, which is the market reality of the costs related to external auditing as well. I think that if you have, you are accountable, you have a mature privacy program, you can demonstrate on demand, you know, all the controls that you have in place, and you are open and you have that communication line open with the regulators to talk about, you know, demonstrating your accountability. I do think that there are maybe better ways to spend your money, because I'd rather put money into training internally, into resources for conducting more PIAs, into other things which really advance the effective protection of the data rather than third-party auditing.
Okay, so questions from the audience, please. I see. Let's have three. Laura Ballard, Charles Rabb, and I can't see your face. Okay. So, yeah. Let's have three questions and then in a group, and then we'll answer them collectively. Sure. And then hopefully we'll get to the others.
Okay, thanks, Colin. Well, I mean, I think your question about audits is a very good one. And I'm wondering if the weak link here is that the privacy officer is still not really a standardized or regulated profession. So, you know, an audit sort of brings to my mind the analogy towards the role of an accountant, you know, where I've seen even the smallest nonprofit organization will hire an independent accountant to do the audit. And why is their independence not compromised by the fact that they're being paid by that party? Because the accountant themselves, the accountants as a profession themselves have their own standards. You can be kicked out of the profession for doing it badly. And I just wonder, where do we need to take privacy officers as a profession if that's going to be credible? Because I think right now what we have is a bunch of different people with privacy officer in their title, and some of them play an auditing role, some of them play a lobbying role, some of them sound like a walking infomercial for their company's products. I think it's all over the map, and I'm guilty as charged. I mean, my role is special advisor for privacy and technology, and somebody asked me last night, well, you know, what does the "and" technology mean? And I said, I don't know, it looks good on a business card. So, I think that's where we are now, and that's probably why this privacy officer is on the whole, is not something, it's not something that the regulator can today rely on to adhere to certain professional standards.
Okay,
but what do we do to change that?
So the role of the CPO in all of this. Now, Charles.
Thank you. Charles Rabb, University of Edinburgh. First, let me get in a plug for the panel that Ivan Zeke and I are running at 11:45 this morning, which looks at the relationship between DPOs and DPAs more generally, not just with regard to accountability. But what I want to say, and the question I want to ask, and I'm generally supportive of the direction in which the accountability movement is going, maybe this picks up Colin's question, you know, what do I as individual data subject, citizen, consumer get out of this? Why am I frozen out of this process? It seems to me that in talking about the demonstration of accountability to a regulator or to a third-party auditor, it leaves open the question of why can't the organization be proactive in getting its account out there, in getting its story out there, in doing the demonstration as part of a public performance, so that it doesn't have to wait for the knock on the door by a regulator, so it doesn't have to wait for an annual set piece thing by which it does it. And in that case, if it were to be able, and of course this may not be scalable, to get out its demonstration to the public in some manner or means of communication, so that that people can say, we're not frozen out of this. We can see how they interpret the law. We can see how they decide what is personal data, what is not personal data. And therefore, maybe if we think that they're doing their best and not just take the regulator's word for it, the regulator who's going to be lenient, then maybe we can increase our trust in the organization. And if trust is what it's all about, this may be a way forward. And I just wondered what your reaction would be to that.
Okay, thank you. And then one final one here from...
Hilke Heijmans. My question is a bit a follow-up on what Charles says, but this whole concept, there is a big role of the regulator already from the start. He is involved, he plays a role in what happens in the context of accountability. It's a bit a follow-up of Colin's point as well. How can you avoid that a regulator is not co-responsible for the result? How can he still be independent afterwards and in an independent way enforce the law, whereas he has been part of the whole process already? It's a bit the same question you asked, but in a different way. It's the responsibility.
Okay, so thanks. So who wants to take any one of those? Terry.
I can take I can't really speak to the profession of how it's going to evolve for the privacy office, but for Charles and Hilke, for the individual, and come back to yourself, a responsible and accountable organizations is going to have all the processes and procedures in place so that the individual would have a vehicle for the organization to hear their complaints, manage their access requests. As compared to an organization without a privacy management program, they would just react in a compliant manner potentially, but they wouldn't have the process and procedures and training in place to deal with the data subject. So what we're proposing here is better for the data subject to communicate directly with the organization and ultimately go back to the regulator. And Hilke, we're not asking for the laws to change or for the regulator to change. We're asking for incentives for organizations to put in privacy management programs, but we're not asking them to change their job of enforcing the law. If there's an incident of non-compliance, we're asking them to do what they're already doing today, is to be lenient with the organization as they are today if the organization is doing the right things or trying to do the right things.
Marty?
A couple of points. The whole question of third-party review has been talked through 1,000 times, and much of the issue comes down to pure money. We did a session back in 2011 on what is an audit and what does an audit cost, and if an audit is just to establish the existence. If an audit is just to establish the existence of a program, it's just duplicating what Terry is talking about in terms of the process of his process, and it's a fairly inexpensive process to do an audit about the existence. If you're asking for a reflection of the effectiveness of a program, that becomes a hugely expensive undertaking, like 10 times the cost of trying to establish the existence, and there has been a reluctance on all parties to push that cost onto organizations on an economy. When you talk about third-party accountability agents, you then get to the same issue. Those third-party accountability agents that can just ask the general questions about the existence are fairly cheap to do, and they're often untrusted because they are just looking at pieces to see if there's existence. To establish a third-party accountability agent that is skilled enough to make a judgment on effectiveness then means a whole different skill set, and there's not the capital in the market to support that. And I'm really mean that. There is no capital in the market to support that type of activity. Right. So it's just important to understand it. When it comes to, I'm not asking for anything different on the regulator, or I'm not asking anything different on the data protection officer. I actually am. I will be obnoxious enough to say that the nature of the way technology works today means that we need data protection officers who are much more skilled in understanding how to interpret the fairness of algorithms than we do establishing.
So this,
that there's a much higher skill level that's necessary. And when I look at regulators, they too have to advance their skill levels in making a judgment on whether a program has integrity.
Okay.
And that's an important part of
So,
this.
quick comments, and then I want to get another round of questions in, if possible. Christopher.
Just a very quick comment. I'd like to emphasize something that hasn't come out yet, which is the responsibility with the regulator to provide support. Because if you're saying you should be accountable, then I think the organizations that you're working with can only benefit if you'll actually do something proactive as a regulator and say, this is what we think that the definition is. And we've got a policy now of trying to produce guidelines, like video surveillance or so on. And we do it for two reasons. Firstly, to aid the controllers, so they can just get on and do it as accountable. But when they notified us for a prior check, for example, if they say, look, we've read your guidelines and we have followed them on everything except this, then in fact it's great for us because it speeds it up. We do a very formal, quick check where they followed the guidelines. We take it on trust, and we do the discussion and the examination on the remaining parts. And then to respond to the question brought in about the co-responsibility, well, we do have a program of follow-up spot checks. And we will go in, for example, with our video surveillance guidelines, we have gone in and we have seen if the organizations have actually done what they promised to do. So it's not a blank check accountability. It's saying, we will help you, here's what you have to do, we will take on trust, but either through a spot check or a complaint, if you find that the controller has not done what they said, at that point you go into classic regulator mode.
Okay. I'd like to just take one or two comments from the audience, and then perhaps we can have a final wrap-up here. So I see 1, 2. So very quickly, brief questions, please. And then, sorry. I see a gentleman in the middle there and in the front row here.
Thank you. So my name is Jean-Pierre Rubaud from EPFL in Lausanne. I'm a computer scientist, and so I'm very intrigued by all the statements that have been made. One thing that strikes me particularly is scalability. All the things we are talking about is computers and people. How much do you think that the supervision of what is happening can be automated in some way by letting computers helping us that actually there is compliance in what is happening within the organization?
Okay, that's a good point. So a quick question here, and then a quick question here, and then I'll let everybody on the panel have a final say before the bell rings.
Thank you. I was wondering, when we go from compliance to accountability and we make consumers more aware of what is happening, what will companies do with the possible fallout that comes from that? Because I might think that some consumers will be shocked to see what's actually happening to their data and what companies actually do.
Okay, thank you. And a final comment on the front here, please.
Hello, my name is Marie Bonthuis. I'm a privacy lawyer and also a PhD. I don't really have a question, but maybe an insight, very fresh, so forgive me if it's spaghetti.
It's brief.
Yeah, sorry. I think if you compare accountability and compliancy, we talk about different scales, and I don't think you can justify accountability with the directives and regulations on the scale of the compliancy. I think it's two different levels. The one protects the individual and the other the society as a whole, so maybe we need another framework for accountability. That's what I wanted to say.
Accountability 3.0, you're suggesting. So, brief comments from Michael. I cut you off earlier, please.
Yeah, no, I just wanted to react on a couple of questions that were asked before, and then maybe on that fresh question also about IT and automation. So, about data subjects, and very briefly about data subjects transparency. But I think that, a good example there is BCR, right? BCR are published. So you have to publish your standards, your rules, and your rules are not the ones from another company. So you develop them together with the regulator, you agree on them, and then you publish them. You put yourself out there to the data subjects. And then, of course, as someone mentioned earlier, it also all relates to how you react and how you interact with the data subjects whenever there's a question coming up. Yeah. On the question about the role of the regulator and whether they're really aside from the topic here and whether they take responsibility or co-responsibility, I think, again, that BCR is quite a good example. I mean, in the relationship that we've had with our lead DPA throughout the binding corporate rules approval process, they have taken responsibility in helping us shaping our binding corporate rules, but also in working with the co-reviewer data protection authorities, in going through the mutual recognition procedure, in sending that out for the cooperation procedure countries as well. And I do believe that, you know, we've got their full support as well moving forward whenever there's a question for phase 2, which is about, you know, the permits and authorization. So I think that the regulators take some part of co-responsibility and kind of advocate, you know, the maturity of your privacy program when it comes to binding corporate rules. And then last comment I want to make is about your question related to whether we can automate a certain number of things. Well, I think yes, there are clearly a certain number of things we can automate. There are certain kind of field level controls that we know need to be in place. Like, you know, if you have a system that processes credit card data, well, you know, you've got these PCI standards, you know, you've got to do something, right? So some kind of data fields, social security numbers, immediately, you know, it triggers some level of encryption that is required or whatever. But at the same time, I also want to balance that a little bit, because we have a lot of discussion like this when, for instance, at Johnson Controls, when we deploy big ERP projects, for example, and we have meetings with the project teams in IT, and they have these questions about, okay, you know, what are the privacy controls? Can you give me a list of fields and the controls behind it? And I'm like, no, I cannot do that, because it all depends on why you're collecting the data. What are you going to do about this? How do you make that proportionality balancing exercise? And that is not something you can really automate. And that comes down to, you know, fairness of processing. That comes down to that you know, judgment call that you have to make to balance, you know, proportionality. Yeah. Okay. Scott.
There were so many good comments from the audience. Related to audit, I think audit is a critical part of that assurance that I was talking about. I would agree that audit resources and dollars need to be applied to actually assessing the risks that you have identified as part of your overall governance. So we do a lot of auditing, and in large companies, there are very independent internal audit organizations that you can use. Focus on where you've identified a risk and you have mitigated it. The audit comes in to ensure that the mitigation has been successful. I'm happy to demonstrate that. A third-party audit of whether I have a program can often be expensive and meaningless, to Marty's point. Charles, your comment about companies actually need to talk about the programs. A number of companies have begun doing that. For 5 years, we have been reporting our privacy program and the demonstration of that, including talking about what accountability is to us, how we manage it, how we manage our data protection board, who the members are, what our risks are, the audits that we have done, you know, the mitigations of that. I would encourage you, I would love to get your comments on, are we doing enough? Is it explaining the program? Is it accessible? But a lot of companies have begun incorporating that in their global citizenship reports with the environment, with human rights, with other things. But I think we could maybe make it easier for people to understand. Related to codification, I agree with Michael. Think about big data. We have got to start codifying data in a meaningful way to help aid in the judgment that Marty and Michael were talking about. But that's going to require some industry standardization. What frightens me related to big data is I'm not even sure what the difference is going to be from primary data that the data subject has provided, and we start mixing it with inferences and data that machines have created, and we can't even tell the difference 3 generations down the road of whether this is real data or it's some inference that a machine has made. We have to get to codification, but it plays a baseline in supporting ultimately what is going to have to be human decisions and judgment based on ethics and responsibility.
I think we should probably wrap it up now. I hear people having coffee. So, Terry, okay, one final brief comment. The bell hasn't rung, so I guess that's... legal. It's compliant. Oh, there you go. Quickly.
Okay. Any feedback that you would have on what the paper presented would be great. Also, you've got this in your handout. It's about a project we're running on interoperability that talks about rules-based demonstration of accountability. So feedback on that would be great. That's it.
So thank you, everybody. Please join me in thanking the panel.